Welcome to the Deep Dive. Now, this deep dive is specifically for educational purposes, really designed to help you get to grips with and study the principles of company law.
And we should say we're really grateful for the material that's been made available by the University of London, which is, the backbone of our discussion today.
Absolutely. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Okay.
All right, so today we are diving into, well, a really critical and, frankly, sometimes quite dramatic area of company law, lifting the veil of incorporation.
Yeah, it does sound a bit cloak and dagger, doesn't it? Lifting the veil, uncovering something hidden.
It really does. And to properly understand why we even need to talk about lifting the veil, we absolutely have to start with the foundation stone of company law. You know, the one.
Ah, yes. Salomon. Salomon v. Salomon & Co., Ltd. That's the one. The big case establishing that a company is its own legal person.
Separate from its owners, the shareholders.
Completely separate. It has its own rights, can own property, can sue and be sued, and crucially, it has its own liabilities.
And the main attraction of that for shareholders is, of course, limited liability. Your personal house, your car, generally safe if the company goes under.
Right. You typically only risk the money you put into the shares. And, that concept has fueled so much business and investment over the years because it limits that personal risk.
But, and here's the but, because the company is separate, that very separation, that shield of limited liability, well, it can be misused, can't it?
It certainly can. People might try to use the company structure to, say, dodge personal debts or responsibilities they'd otherwise face.
And that's exactly where this idea of lifting the veil enters the picture. Our source material frames it as the law stepping in, intervening to control that potential for abuse.
Yeah, and it's important, as the source points out, that lifting the veil isn't always about pretending the company doesn't exist at all. That's quite rare, actually.
Right. So what does it usually mean then?
More often, it means the law finds a way to impose personal liability on the people behind the company directors, maybe shareholders, even while the company itself is still seen as a separate entity. It's about finding someone else responsible.
Okay. So our goal, our mission for this deep dive is to sort of pull back that veil a bit and understand the main ways the law does this. We'll look at specific laws Parliament made.
The statutory roots.
How the courts have approached it over time.
It's the judicial angle, yeah.
And also how you might sue individuals directly using tort law. We really want you to get a solid understanding of the main ideas, the key cases, and crucially, the differences between these approaches. That way, you'll be ready to tackle questions on this topic.
Sounds like a plan. It's a complex area, so breaking it down is key.
Okay, let's start unpacking it. Where should we begin? Maybe with the rules Parliament set out. They seem a bit more concrete.
Good idea. Legislative intervention. Parliament has stepped in, especially when companies get into financial trouble, insolvency situations. The Insolvency Act 1986 is the key piece of legislation here.
Right, the Insolvency Act 1986. And it gives us specific tools.
Yes, two really important ones highlighted in our source, Section 213 and Section 214.
Okay, Section 213 first. That one's called fraudulent trading. Sounds serious.
It is. Section 213 targets the really bad cases where a company was basically run with the deliberate intention of ripping off creditors. The key phrase is carrying on business with intent to defraud creditors or for any fraudulent purpose.
Intent to defraud. That sounds like it could be quite hard to prove in court.
Extremely hard. It's a high hurdle. But if you can prove it during a winding up, the court can make anyone who is knowingly involved contribute to the company's debts, usually directors, maybe shareholders.
Any examples?
Yeah. The source mentions Re Todd Ltd. In that case, a director was found liable under the section and had to pay up.
And didn't the source also mention something about a criminal offense being linked to this?
Yes, that's right. Section 993 of the Companies Act 2006 actually makes fraudulent trading a crime, potentially leading to prison. But interestingly, that criminal aspect kind of backfired on the civil use of Section 213.
How so? Making it a crime made the civil claim harder?
Sort of, yeah.
Yeah.
Because the consequences were so severe, potentially criminal, courts interpreting Section 213 for civil liability demanded a very high standard of proof for that intent to defraud. They wanted actual dishonesty, real moral blame. That phrase comes from Patrick and Lyon Ltd.
Real moral blame. Okay.
Proving that specific, subjective, dishonest intent made Section 213 difficult for liquidators just trying to get money back for the people the company owed.
So if proving deliberate fraud under S.213 was so tricky, did Parliament come up with something else?
Exactly. That led to Section 214, wrongful trading. It was designed to catch director misconduct that wasn't necessarily outright fraud, but was still pretty bad. A lower bar, essentially.
Okay, Section 214, wrongful trading. What's the test here if it's not intent to defraud?
The trigger for Section 214 is about continuing to trade when a director knew or ought to have concluded that there's no reasonable prospect of the company avoiding insolvent liquidation.
No reasonable prospect.
Oh.
That sounds more objective. Less about dishonesty, more about, well, negligence, not facing reality.
Precisely. It focuses on what a reasonably careful director with the skills expected for their role should have known or figured out. Did they keep trading past the point of no return when they should have seen insolvency coming?
And if they did, what's the consequence?
Similar outcome, the court can make them contribute to the company's assets, basically covering the extra debts piled up after they should have stopped trading.
Is there a key case for Section 214?
Yes. Reproduce Marketing Consortium Ltd. number 2 is the classic example. Reproduce Marketing Consortium.
What happened in Reproduce Marketing Consortium?
Well, the directors basically kept the company going for years, even though it was clear, or should have been clear, that it was insolvent and couldn't recover. When it finally collapsed, the court used Section 214 to make them liable for about £75,000, representing the amount the company's debts increased after the point they should have realized there was no reasonable prospect.
Okay, so S243 for fraud, S214 for negligence and continuing to trade. And the course makes a point about these sections not strictly being veil-piercing.
Yeah, it suggests they don't ignore the company's existence. Instead, they impose a separate additional personal liability on the directors or individuals involved alongside the company's liability. It's a subtle but important distinction. They act as a deterrent, hopefully.
Right, so those are the statutory tools in insolvency. But the courts can also step in, even without a specific law, though you said this area is trickier.
Oh, much trickier. Less certain. The court's attitude has definitely shifted over the years. There was a time, maybe in the 70s, with cases like DHN Ltd v. Tower Hamlets, where some judges seemed quite willing to look at a group of companies and say, look, economically, this is all one unit, let's treat it as such legally.
That sounds pragmatic, but maybe messy legally.
It proved to be. That single economic unit idea was pretty heavily criticized later on, particularly in a case called Wolfson v. Strathclyde RC. The modern approach, the one you need to know now, is much, much more restrictive about when judges will ignore that separate personality.
And the case that really sets out this modern restrictive view is...
Adams v. Cape Industries. Absolutely fundamental. You have to know Adams v. Cape.
Yeah, Adams v. Cape Industries. What were the basics? Something about asbestos?
Yeah. Simplified, you had U.S. workers injured by asbestos exposure from subsidiaries of an English parent company, Cape. They got judgments in the U.S. against Cape, but needed to enforce them in England. To do that, they had to show Cape was legally present in the U.S.
And they tried to argue Cape was present through its subsidiaries by lifting the veil.
Exactly. They argued, treat the subsidiaries' U.S. presence as Cape's presence. And the Court of Appeal had to decide if that was legitimate grounds for lifting the veil.
What did they say? Did they lift it?
No, they didn't. And importantly, they shot down two key arguments. First, they said you absolutely cannot lift the veil just because it seems like the interests of justice demand it. Too vague, too uncertain.
So just feeling sorry for the claimants isn't enough.
Not nearly enough for veil lifting. Legal certainty matters. Second, they firmly rejected that single economic unit argument from DHN. Just because companies operate commercially as a group doesn't destroy their separate legal personalities.
Okay, so no lifting for justice, no lifting for single economic unit. When did the Adams Court say you could lift the veil?
Well, they acknowledged it might be necessary when interpreting a specific statute or contract. But the main category they focused on was where the company is being used as a mere facade concealing the true facts.
A mere facade. What does that actually mean?
The court in Adams looked at older cases to understand this.
Yeah.
Cases like Guilford Motor Company, Ltd v. Horn, remember that one?
Guilford v. Horn. Wasn't that the guy who left his job, promised not to compete, then set up a company immediately to do exactly that?
Precisely. Using the company to get around his non-compete clause. Or another classic, Jones v. Littman.
Ah, Jones v. Littman. The man agreed to sell his house, then changed his mind and quickly transferred it to a company he owned to avoid the sale contract.
Right. In both Guilford and Jones, the company was essentially a sham, a puppet. used specifically to avoid a legal obligation the person already had. That's the core idea the Adams Court took. The facade principle applies when you set up or use a company to dodge a pre-existing obligation.
And in Adams, Cape hadn't done that.
The court found Cape hadn't used its subsidiaries to avoid an obligation it already owed. It structured itself using subsidiaries to insulate itself from future potential liabilities, which, the court said, is generally a legitimate use of the corporate structure under Salomon. So, no facade, no lifting the veil in Adams v. Cape Industries.
They also mentioned agency, but said that's just applying normal agency rules, not really veil lifting itself.
Correct. So Adams really narrowed the path for judicial veil lifting, and this narrow view was then powerfully confirmed and maybe refined by the Supreme Court more recently in Prest v. Petrodel Resources Ltd.
Prest v. Petrodel, another massive case in this area.
Absolutely crucial. Prest v. Petrodel. Lord Sumption, in his leading judgment, introduced a really helpful distinction. He talked about the concealment principle and the evasion principle.
Okay, concealment principle first. What's that?
Concealment is just using a company structure to hide the real facts, maybe who really owns something or who did something. Think of hiding assets during a divorce, perhaps. The court can look through the company structure to see the reality. They can conceal the truth. But crucially, Lord Sumption said this is not piercing the corporate veil. You're not ignoring the company's existence. You're just finding out what happened behind it.
So you're looking behind the veil, not piercing through it.
Exactly. Now, the evasion principle, according to Lord Sumption, is different. This is where someone uses the company specifically to frustrate or get around a legal right or obligation they already have independently of the company, like in Guilford or Jones. And Lord Sumption argued that this, the evasion principle, is the only situation where the court will truly pierce the corporate veil, disregard the company's separateness to enforce the obligation against the controller.
Wow. So Prest really doubled down on the Adams approach, saying true veil piercing is incredibly rare and limited just to that evasion scenario.
That's the state of play. For your studies, you need Adams and Prest down cold. Know the arguments Adams rejected, understand the narrow facade or evasion ground, and grasp Lord Sumption's concealment versus evasion distinction from Prest. That's absolutely key.
Okay, so we have the statutory rules in insolvency, and we have this very limited judicial power to pierce the veil under the evasion principle. Given how hard it seems to be to pierce the veil judicially, what other options are there if someone's been harmed by a company's actions? Can they go after the individuals directly?
Yes, and that's the third main area we need to cover. Actions in tort directly against directors or shareholders. This is important. It's not veil piercing. It's about establishing that the individual director or shareholder committed a tort in their own right.
So you're not trying to ignore the company. You're saying this person, in addition to the company, also wronged me.
Precisely. Think about a simple example. If a company employee driving a company van negligently causes an accident, the injured person can sue the company, vicariously liable, and they can sue the driver personally for their negligence. The driver doesn't escape liability just because they were working for a company.
Right. Okay. So employees are liable for their own torts. But what about directors acting as directors? That seems the more complex issue.
It is. Obviously, if a director commits a tort completely unrelated to their duties, they're liable. But for actions taken as a director, maybe making a decision that leads to harm, the courts are often more cautious. There's a reluctance, mentioned in cases like MCA records, to hold directors personally liable just for, exercising control through the company structure.
So how does a claimant overcome that reluctance?
It depends on the specific tort. A really important area is negligent misstatement, giving bad advice or information. Here, the key case is Williams v. Natural Life Health Foods, Ltd.
Williams v. Natural Life Health Foods. What's the rule from that case?
Williams established that for a director to be personally liable for a negligent statement made by the company, the claimant has to show the director assumed a personal responsibility for that statement directly towards the claimant. Just being the director isn't enough.
Assumed personal responsibility. What does that involve?
It usually requires something more than just signing off on company brochures. Maybe direct personal dealings, giving specific assurances, acting in a way that shows the director was personally vouching for the information, not just the company. It's quite a high threshold set by Williams v. Natural Life Health Foods.
That sounds like another significant hurdle for claimants.
It can be, yes. It protects directors from being sued every time a company's statement turns out wrong. But, and this is important, the need to show assumption of personal responsibility generally applies to negligence. If a director commits the tort of deceit, meaning they knowingly make a false statement or are reckless about its truth, then you don't need to show they assumed personal responsibility. Fraud is different. Cases like Dato and Standard Chartered make that clear.
Okay, so personal liability for directors is possible, but often requires that assumption of responsibility for negligence, but not for deceit. What about shareholders? Specifically, parent companies and the torts of their subsidiaries.
Right. Again, shareholders are liable for torts they commit directly. The really debated area is whether a parent company can be liable for harm caused by its subsidiary, especially if the parent didn't do anything directly, but maybe failed to prevent the harm and omission.
There was a case, Chandler v. Cape Pludak, that seemed to open that door, didn't it?
Yes. Chandler v. Cape caused quite a stir. It involved asbestos exposure again. The court suggested a parent company could owe direct duty of care to its subsidiaries' employees if certain conditions were met, like both companies being in the same business, the parent knowing about the dangerous working conditions, and the subsidiaries' employees relying on the parent's supposedly superior knowledge or safety procedures. It looked like liability for omission was possible.
Chandler v. Cape. But has that approach held up?
Not entirely. The courts have kind of walked it back since then. Cases like Thompson v. Renwick Group clarified that Chandler wouldn't apply to a pure holding company that just held shares and wasn't involved in the subsidiary's actual business operations.
So where are we now with parent company liability? What do the big Supreme Court cases say?
The current position has really been shaped by recent Supreme Court decisions, particularly Vedanta Resources, Pelekji v. Longo, and Okpabi v. Royal Dutch Shellopik. These are crucial.
Vedanta and Okpabi, what's the message from them?
The key takeaway from Vedanta and Okpabi is that parent company liability for a subsidiary's torts generally depends on the parent's active misfeasance.
Active misfeasance. Can you explain that a bit more?
It essentially means the parent company isn't usually liable just for failing to supervise or intervene omission. Liability arises when the parent company has actively intervened in or taken over, or given specific advice regarding the management of the particular activity of the subsidiary that caused the harm. It's about the parent's own actions contributing to the damage, not just its relationship with the subsidiary.
So the focus shifted away from the Chandler factors, like knowledge and reliance, towards needing proof that the parent actively got involved in the specific harmful operation, like running that part of the subsidiary's business.
Pretty much, yes. It requires a more direct link between the parent's actions and the harm caused by the subsidiary. Understanding that shift towards requiring active misfeasance, thanks to Vedanta and Okpabi, is vital.
Okay, that makes sense. It brings liability back to the parent's own conduct.
Exactly. It shows the courts trying to balance accountability with respecting the separate legal personalities established by Salomon.
Right, this has been a really thorough walkthrough. We've covered the legislative rules, the very narrow judicial veil piercing, and this separate route of direct tort liability. For someone studying this, it feels like the main challenge is knowing which path applies when and what the specific test is for each.
That's absolutely it. First step. Always start with Salomon. Separate legal personality, limited liability, that's the default. Then you need to know these different ways the law intervenes.
Okay, so know the starting point, then the interventions.
Right. For the legislative side in insolvency, you need Section 213, fraudulent trading, intent to defraud, hard to prove, repatriate in line, and Section 214, wrongful trading, no reasonable prospect, negligence, reproduce marketing consortium, know those tests.
Got it. And for the judicial side,
It's all about Adams v. Cape Industries and Press v. Petrodol. Know the grounds Adams rejected, interests of justice, single economic unit. Know the one narrow ground it accepted, mere facade, which Prest refined into the evasion principle, using the company to dodge a pre-existing obligation. And remember Prest's distinction. Concealment, looking behind, not piercing, versus evasion, the only piercing ground. Know Guilford and Jones as examples of evasion.
okay. Adams and Prest for judicial piercing, focusing on evasion. And then tort.
Remember, tort is different, not veil piercing. For directors, think Williams v. Natural Life Health Foods needing assumption of personal responsibility for negligent misstatement, but not for deceit, Dato Standard Chartered. And for parent companies suing over subsidiary actions, know the journey. Chandler v. Cape's initial suggestion of a DUI, limited by later cases, and now the Vedanta and Okpabi requirement for the parent's own active misfeasance, direct involvement in the harmful activity.
Active misfeasance. Right, so the key is knowing the rule for each situation, intent to defraud, no reasonable prospect, evasion principle, assumption of responsibility, active misfeasance, and knowing which case backs it up.
Exactly. And for those key cases, Salomon, Guilford, Jones, Adams, Prest, Williams, Chandler, Vedanta, Opabi, try to know the basic story, the legal issue, what the court decided, and why. That helps you apply the principles to new scenarios, which is what exams often test.
Okay, well, let's just quickly rattle off those key terms and cases one last time for everyone listening.
Salomon principle.
Limited liability.
Lifting the veil.
Fraudulent trading, Section 213.
Wrongful trading, Section 214.
Adams v. Cape Industries, PL.
Prest v. Petrodol Resources, Ltd.
Evasion principle.
Concealment principle.
Guilford v. Horn.
Jones v. Lippman.
Williams v. Natural Life Health Foods, Ltd.
Assumption of personal responsibility.
Chandler v. Cape Pile.
Vedanta Resources PLEV Lungo.
Okpabi v. Royal Dutch Shell PLOD. Active misfeasance.
Get those locked in, and you've got a strong foundation.
Definitely. So as you mull all this over, here's something to think about. Given how restrictive judicial veil piercing is now, focusing just on the evasion principle, and the current active misfeasance approach for parent company torts, do you think the law currently strikes the right balance? Does it adequately protect people harmed by corporate actions while still upholding the benefits of limited liability from Salomon? Or perhaps think about Section 214. How would you analyze a situation where directors genuinely disagreed about whether the company had truly reached that point of no reasonable prospect?
Good questions to reflect on. Definitely encourage you to go back over your notes and the source material from the University of London.
And that brings us to the end of this deep dive. Just a reminder, this was created for educational purposes to support your study of company law. It was made possible by material from the University of London and brought to you by Sinorbit Academy, Sri Lanka.
Thanks very much for tuning in.
We hope you found it helpful, and we'll catch you on the next dive.